Hi everyone, my name is Larry Sidiropoulos, and today's topic is what to do once and if an insurance company refuses to pay your claim. Obviously, once you've gotten to the point where you've fully ascertained or determined what your injuries are and what your damages are, including your lost wages, your medical bills, your general damages, which includes pain, suffering, and inconvenience, you can attempt or demand that the insurance company settle your case. In most cases, unless you file the lawsuit, insurance companies are not going to offer you full value on your case. They're generally going to lowball you, so you have to be ready, willing, and able to proceed into litigation and ultimately to proceed to trial. So, if you're at the early stages of a case, that is, you've been injured, approximately 6 months have gone by, you've gotten all your medical treatment, you've lined up all your damages, including lost wages, medical bills, and pain, suffering, and inconvenience, you're at a point where you could probably make a demand for settlement on the insurance company. If obviously after you provide this demand for settlement, if they either refuse to settle with you at that stage or they lowball you on the value of your case, your next and only recourse would be to file a lawsuit. So at that point, and well before that point, you should have a reputable attorney representing you in order to maximize your recovery, both in the event that you try to settle the case and, most importantly, if you file a lawsuit and proceed to trial, you need to have an attorney that knows what they're doing and comfortable in the personal injury arena. So, in some cases, I've had clients walk into my office after they've attempted to resolve the case on their own. They were discouraged because the insurance company told them they didn't have a viable case, that there was no liability in their favor, that they didn't have actual damages. And in many of those cases, it turned out to be false. Insurance companies are notorious for trying to get you to resolve your claim or case early. That is, before you fully ascertain the liability arguments, who's at fault, and before you fully ascertain your actual damages. I would never recommend to anyone to try to resolve your case before you know the full extent of your damages. If you're still having pain and discomfort and you're still incurring medical bills, it's not the time to resolve your case. You need to get to a point where you've either plateaued in your physical condition and you're just not going to get any better, or you've come to a point where you're exactly where you were physically before the accident occurred. That's the time to try to, determine what your damages are and try to resolve the case. In some cases, if an insurance company either inappropriately contacts you, for example, in your hospital bed after an accident, or if they're trying to force you to sign documents that you're not obligated to sign, or if they're just simply not treating you fairly as far as the valuation of your car after it's been damaged in an auto accident, and you feel you've been wronged, you can file a complaint with the California Department of Insurance. And you can do that online, and sometimes that is helpful. The best thing to do is to hire and consult with a reputable attorney you can trust that was either recommended to you, or I would recommend speaking to at least 3 different lawyers before you make your decision as to who to hire. I'm available if you'd like to sit down with me at no cost to you. I'll spend at least an hour to 2 hours with you. I'll answer any questions you might have, and I'll let you know what to expect during the course of a personal injury case, before litigation and after. So if you're interested, please contact us in the information provided below. I remain available to meet with you in person, and I look forward to speaking to you soon.